I dare you to fix me. I'm crossing the line again, falling on my knees.
What is an opinion? Opinion is an inference or conclusion drawn from facts observed. General rule: the opinion of a witness is not admissible. Exceptions: expert opinion, opinion of an expert on the branch of science, literature, and art, acquired expertise on the knowledge. Ordinary opinion: handwriting, which he has sufficient familiarity, identity about whom he has adequate knowledge, mental sanity of a person he is sufficiently acquainted, the witness impressions of the emotion, behavior, appearance, or condition of a person. Are authors of law books experts? Well, unfortunately, according to this justice, no, it's not. Because he said, mali-mali pa nga ang grammar. Paniniwalaan mo ba raw yun? Note, expert evidence are given probative value, but they're not binding upon the court. Although, yes, they are given weight, but why? Sometimes unreliable, the judge ultimately decides between or among the expert witnesses. When don't you need an expert? For example, the witness is the child of the father, and the issue is the case at bar is the father's penmanship. The child is expected to know his father's penmanship and does not need to be a handwriting expert to know such is his father's. Character evidence. Character means the aggregate of the moral qualities which belong to and distinguish an individual person. Reputation depends on attributes which others believe one to possess. General rule: evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. Basically, this is from the Codal. Criminal cases, the character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the offense charged. The accused may prove his or her good moral character pertinent to the moral trait involved in the offense charged. However, the prosecution may not prove his or her bad moral character. In civil cases, evidence of the moral character of the party in a civil case is admissible only when pertinent to the issue of character involved in the case. Criminal and civil cases. Evidence of the good character of a witness is not admissible until such character has been impeached. In all cases which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. In cases in which character or a trait of character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of that person's conduct. If there is an evidence by prosecution which shows good moral conduct, those kinds of evidence may be used in rebuttal. Here, know that every person is presumed righteous. You don't have to prove that you are good if you are not bad. When will the witness be subject to character evidence? If the moral character of the accused is the subject of the case. There is a doctrine in criminal law which states that one witness is enough if the witness is the offended party. Also remember that if the story is outlandish, then it is not credible. Babaero baga. Rule 131, burden of proof and burden of evidence. Burden of proof, duty of a party to come forward to promote the proponent, to prove the cause of action. Burden of evidence, it depends upon the development of the case. Example, there are individual styles on how we write, and from those differences we can conclude or determine falsification. Stage when burden of proof may be determined. Civil cases, primarily on the pleadings, although it may be changed during the pre-trial and during the proceedings. Under criminal cases, during the pre-trial conference, when the accused raises his defenses, or during arraignment, when the accused raises justifying circumstances. However, the issues may not be changed anymore. Upon whom burden of proof rests? Generally on the plaintiff. The plaintiff is always compelled to allege affirmative assertions. In civil cases, the defendant has the burden of proof if he raises an affirmative defense on the complaint of the plaintiff. In criminal cases, the burden of proof is with the prosecution by reason of the presumption of innocence. Let's differentiate prima facie case and prima facie evidence. Under prima facie case, this is used if only one evidence is present. Also, the entire cause of action here is sufficiently proven by the plaintiff. Under prima facie evidence, this is the evidence or kind of evidence that sufficiently proves a fact or part in the matter in dispute. There is now a burden of evidence on the part of the defendant, which the defendant needs to negate or trump. Preponderance of evidence, this is the evidence both sides give. And then the weightier one is the one that is accepted by the court and or the judge. Presumptions. Presumption, it is an inference as to the existence of a fact not actually known, arising from its usual connection with another which is known, or a conjecture based on past experience as to a course of human affairs ordinarily take. Presumption, one which the rules allow a party to assume on the basis of established facts. Inference is assuming a fact, but there is no legal value, there is no law to prove such. Two kinds of presumption. One, exclusive presumption or presumption juris et de jure. This is also called as conclusive presumption. This presumption cannot be rebutted or disputed and not permitted to be overcome by any proof to the contrary. Number two, disputable presumption or presumption juris tactum or juris tanquetum. One which the law permits to be overcome or contradicted by proofs to the contrary. Otherwise, the same remains satisfactory. Two kinds of conclusive presumption. One is estoppel in pace. Second, estoppel by deed. Estoppel in pace description is whenever a party has by his own declaration, act, or omission intentionally and deliberately led another to believe a particular thing to be true and to act upon such belief, he cannot in any litigation be permitted to falsify it. Requisites as to the party to be estopped. 1. Conduct amounting to false representation or concealment. Number 2. Intent or at least expectation that the conduct shall be acted upon. And 3. Knowledge, actual or constructive, of the real facts. Requisites as to the party claiming estoppel. 1. Lack of knowledge of truth as to the facts in question. Number 2. Reliance on good faith upon the conduct or statements of the party to be estopped. And 3. Action or inaction based thereon to his prejudice. Estoppel by deeds description. It is where the tenant is not permitted to deny the title of his or her landlord at the time of the commencement of the relation of landlord and tenant between them. Points to remember. Number 1. Estoppel may attach even though the landlord does not have title at the commencement of the relations, and 2. Estoppel may inure in favor of the successor. Disputable presumption. A species of evidence that may be accepted and acted on where there is no longer evidence to uphold the contention for which it stands, or one which may be overcome by other evidence. The most important disputable presumption is presumption of innocence, because until an accused or an alleged wrongdoer is convicted of final judgment, he is presumed to be innocent. It is only the prosecution which needs to overcome such. Goal ng prosecution mag-inject ng doubt. If the prosecution fails to prove the guilt, the burden of evidence belongs to the defendant. Here, the accused should submit evidence of moral certainty of doubt, because with that, an accused may be acquitted. Hindi necessary na actual certainty, that is why enough na yung moral. What is disputable presumption? These are the questions that we need to answer. What does presumption of innocence mean? And give example. When there is a decision committing murder, what happens to this disputable presumption? What happens, or when is the presumption of innocence no longer presumed? What is this presumption that officials regularly done or has done their acts? Why? Why is this presumed? Or why is this a disputable presumption? Extrajudicial killing, is that to the advantage of the accused or the prosecution? Why? Regularly performed. I am not guilty because I did my job. Accused with the rules and regulations to justify the act. So, sa policeman, pwede nilang sabihin na naglaban cause it is their duty to do so. In corruption, why did in performance of their duty thou, so the prosecution must destroy this presumption and rebut it. When is a person presumed dead for the purpose of remarriage? Can the spouse already remarry? What happens if the husband reappears? Effect of reappearance. Can he demand the wife to come back to him? Effect of a reappearance of the spouse. Can he demand priority right? First marriage deems vacated, and the first marriage shall resume. The children sa second husband legitimized na. Another presumption of death. After 4 years, can the estate be subject to probate? Is it possible that the person presumed dead be alive? What happens to the distributed property? Can insurance be claimed by the heirs? In insurance, the rule is different. The insurer needs to see evidence that such person is physically dead. This is specified in the contract of insurance. Explain the presumption that the one who holds the thing delivered to another belongs to another. How do you kill a presumption regarding death? When is theft subject of presumption? Take note that all these disputable presumptions may be rebutted. It can be disputed. If you are a debtor and you execute a promissory note, what can the creditor do? What do you do to that promissory note? What if it was returned to you? What is the presumption? A creditor will not release a promissory note until it is paid, so there will be a presumption that the debtor has paid already. Example, you bought a car, but you paid for it in excess. Can you reclaim the excess payment? No. You can no longer ask for your money because kasalanan mo yun. The law does not protect you from your own ignorance. What should characterize the absence to make the presumption operative? Absent. Whereabouts are unknown, or the person who must know doesn't know. Where can his estate go when he is already presumed dead? Are there times when a lesser period of time in the opening justified? How about the police? What rule is applicable? Is it the same as the AFP? What is the rule for remarriage? What happens if a witness is presented to testify? Difference between oath and affirmation. What is the other term for direct examination? What is direct examination? Rule 132. Examination of witnesses. Done in open court. Number 2, orally and under oath are affirmation. Can it be given in any other way that is not orally? Yes. If the question calls for a different mode of answer, the witness is incapacitated to speak, the testimony may be given in affidavits or depositions. Is recording necessary? Yes. The entire proceedings of a trial or hearing including the questions and answers, statements made, shall be recorded. How? Shorthand, stenotype, or by other means of recording. Is the transcript made by the official stenographer, stenotypist, or recorded deemed prima facie a correct statement? Yes, as the law provides for it. Right and obligations of a witness. 1. To be protected from irrelevant, improper, or insulting questions, and from harsh or insulting demeanor. 2. To not be detained longer than the interest of justice require. 3. To not be examined except only as to matters pertinent to the issue. 4. To not give an answer which will tend to subject him or her to a penalty for an offense unless otherwise provided by law. Or 5. To not give an answer which will tend to degrade his or her reputation unless it be to the very fact at issue or to a fact from which the fact in issue would be presumed. There are a lot of facts there. The witness must answer to the fact of his or her previous final conviction for an offense. Right against self-incrimination of a witness. General rule. A witness should not be compelled to give an answer which will tend to subject him to a penalty or offense. Exception, if it's provided by law. Leading and misleading questions. Leading question, a question which suggests to the witness the answer which the examining party desires. Misleading question, ones which assumes as a true fact not yet testified to by the witness, or contrary to that which he has previously stated. It is not allowed in any type of examination. General rule, it is not allowed. Exceptions. 1. Cross-examination. 2. Preliminary matters. 3. When there is difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender years, is of feeble mind, or a deaf mute. An unwilling or hostile witness, or a witness who is an adverse party, or an officer, director, or managing agent of a public or private corporation, or of a partnership or association which is an adverse party. Reason for allowing leading questions. The witness is not the cross-examining party's witness. He is expected to be adverse or hostile to the cross-examiner. He is not expected to cooperate. What are the ways of impeaching? By contradictory evidence, by evidence that the general reputation for truth, honesty, or integrity of the witness is bad, or by prior inconsistent statements. Are these the only modes? No. There are other modes which Section 11 did not add in its provision. By involving him during cross-examination in contradiction, by showing the impossibility or improbability of his testimony, by proving action or conduct of the witness inconsistent with his testimony, or by showing bias, interest, or hostile feeling against the adverse party. Is credibility affected if the witness has a prior conviction? Yes. It does not matter if the crime is serious, of a light or minor offense. Can a party impeach his own witness? Generally, no. A party is not allowed. Are there exceptions? Yes. Witness is required by law. Witness is an adverse party, or witness is an unwilling or hostile witness. Laying of a predicate. Impeachment of a witness through prior inconsistent statements. Witness is impeached by prior inconsistent statements by laying the predicate. 1. By confronting him with such statements with time, place, and circumstances under which they were made. 2. If the witness admits the making of such contradictory statements, the accused has the benefit of the admission, while the witness has the opportunity to explain the discrepancy, if he can. And 3. If the witness denies, the accused has the right to prove that the witness did not make such a statement. Authentication and proof of documents. Authentication, a formal affirmation by a public official who has custody of a public record that a copy thereof is a faithful and correct copy or reproduction of the original. Public documents, the written official acts or records of the official acts of the sovereign authority, official bodies and tribunals and public officers, whether of the Philippines or of a foreign country. Documents acknowledged before a notary public, except last wills and testaments. Documents that are considered public documents under treaties and convention which are in force between the Philippines and the country of source. Public records kept in the Philippines or private documents required by law to be entered therein. As to authenticity of documents, public documents and private documents. Under public documents, a public document is admissible in evidence without further proof of its genuineness and due execution. A private document, a private writing must be proved relative to its due execution and genuineness before it may be received in evidence. Self-authenticating documents. 1. Official records under seal. 2. Notarized documents. And 3. Certified copies of public records. When authentication is excused in private documents. 1. Ancient document within the context of the rules. 2. When the genuineness and authenticity of an actionable document have not been specifically denied under oath by the adverse party. 3. When the genuineness and authenticity of the document have been admitted, or 4. When the document is not being offered as genuine. Requisites for ancient document rule. 1. The private document is more than 30 years old. 2. It is produced from the custody in which it would naturally be found if genuine. And 3. It is unblemished by any alterations or circumstances of suspicion. Ancient document rule applies only if there are no other witnesses to determine authenticity. Irremovability of public record. General rule: any public record, an official copy of which is admissible in evidence, must not be removed from the office in which it is kept. Exception: upon order of the court, where the inspection of the record is essential to the just determination of a pending case. How is judicial record impeached? 1. By evidence of want of jurisdiction in the court or judicial officer. 2. By evidence of collusion between the parties, or 3. By evidence of fraud in the party offering the record in respect to the proceedings. Alterations in a document. The party producing a document as genuine, which has been altered and appears to have been altered after its execution, in a part material to the question in dispute, must account for the alteration. He must show that 1. Was made by another without his concurrence. 2. Was made with the consent of the parties affected. 3. Was otherwise properly or innocently made. Or 4. Did not change the meaning or language of the instrument. It is presumed that a party producing it or with his privity caused the alteration. The burden is upon him to show that the same was not made by him or his privies. When is it a material alteration? When it alters the terms or language of the instrument, or changes the rights, interests, or obligations of the parties. Offer and objection. What is the vital part of offer of evidence? It is vital because no evidence can be considered unless it is offered, not even when it is marked. Exceptions? When the evidence is properly identified by testimony duly recorded, and if it is already incorporated in the records of the case. What amounts to an offer of evidence? The Q&A amounts to an offer of evidence. How should evidence be offered? All evidence must be offered orally. When should the offer of the testimony be made? The offer of the testimony of a witness must be made at the time the witness is called to testify. When should the offer of documentary and object evidence be made? The offer of documentary and object evidence be made after the presentation of a party's testimonial evidence. When should objection to offer of evidence be made, and how? It should be made orally immediately after the offer is made. When should objection for lack of formal offer be made? It should be made as soon as the witness begins to testify. How about to a question propounded in the course of the examination? It should be made as soon as the grounds have become reasonably apparent. When is formal offer of evidence not required? It is not required in the following. 1. Lost objects previously marked, identified, described in the record, and testified by the witnesses who had been subject of cross-examination. Summary proceedings. Documents, affidavits, and depositions used in rendering summary judgments. Documents judicially admitted or taken judicial notice. Documents whose contents are admitted by the parties. Documents or affidavits used in deciding quasi-judicial or administrative cases, and naturalization, insolvency, cadastral, other cases, land registration and election cases. Nicole. Identification versus formal offer. Identification is done in the course of the trial and is accompanied by the marking of the evidence as an exhibit. Formal offer is done when the party has presented his testimonial evidence. Kinds of evidence. 1. Testimonial evidence. This is offered at the beginning. This is when the witnesses are called to the stand. Documentary evidence. This is offered only after the termination. The purpose is to give the nature and substance. And 3. Object evidence. Judicial affidavit. This contains the direct examination. This also contains the evidence to prove the cause of action. The lawyer is the one tasked to summarize this. Evidence must prove one segment of the cause of action. Notoriety, privileged communication, unsound mind, or if testimony is violative. Objection and no objection. Objection is to stop a testimony. No objection to continue a testimony. Kinds of objection. General objection does not go beyond declaring the evidence as immaterial, incompetent, irrelevant, or inadmissible. It does not specify the grounds for objection. Specific objection states why or how the evidence is irrelevant or incompetent. Leading and misleading question. Violation and rules of PRN, etc. Important. State why the evidence is immaterial or incompetent. This is important so that the court can make a proper ruling. When is the ruling given? Generally, immediately after the objection is made. Can the court not give it right away? Yes, if the court desires to take reasonable time to inform itself on the question presented. Is the reason for sustaining or overruling an objection necessarily needed to be stated? No. But may it? Only if the objection is based on 2 or more grounds. Modes of excluding inadmissible evidence. 1. Objection, or 2. Motion to strike out or expunge. Premature answers, unresponsive answers, answers that are incompetent, irrelevant, immaterial, or improper, incomplete testimonies, unfulfilled condition and conditionally admitted testimonies, and the ground for objection was not apparent when the question was asked. There must be an objection before motion to strike. An evidence illegally seized cannot be available in court. In addition, the rule requires the court to either deny or admit the evidence. What is the rationale of excluded evidence? To notify the appellate court and to be a deposition to determine if there is correct ruling or none. General rule, if the cross-examination cannot be taken, direct testimony is cancelled. Exception, when there is waiver of the objection. What is needed to be done if a question is ambiguous? Ask something that is not definite or a compound question. What is a compound question? Several questions in one sentence. What would happen if the court grants a continuous question? There will be no objection. Rule 133. Weight and sufficiency of evidence. Evaluation of evidence. It is the task of assigning when the evidence is admitted. Hierarchy of evidentiary rules. Proof beyond reasonable doubt. Proof of such a convincing character that you would be willing to rely and act upon it without hesitation, required in criminal proceedings. Clear and convincing evidence. Evidence presented by a party during the trial must be highly and substantially more probable to be true than not, and the trier of fact must have a firm belief or conviction in its factuality, required in habeas corpus proceedings. Preponderance of evidence. Evidence as a whole adduced by one side is superior to that of the other. What's important is that the weight, or what is more convincing, required in civil cases. Substantial evidence. Such evidence as a reasonable mind may accept as adequate to support a conclusion, required in administrative proceedings. Evidence to prove guilt. Direct evidence. There should always be a witness. Circumstantial evidence. It is sufficient for conviction if there is more than one circumstance, the facts from which the inferences are derived are proven, and the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Example. First circumstance. A saw C entering the house of B while holding a gun. Later, A heard a gunshot from inside B's house. Second circumstance, B is the kabit of C's wife. Third circumstance, C told D, papatayin ko si B. Circumstances are pieces of evidence of a crime. Although do not prove anything, once it is put together, it could interlock with each other, creating a conclusion. Is a confession enough to convict? No. In addition to confession, there must be corpus delicti. Example, in insurance, A disappears, tapos the body cannot be recovered. This is not sufficient to support the claim of heirs. Paano if alam naman pala kung nasaan si A, sinabi lang nila para makuha yung pera? Corpus delicti means the fact of the commission of the crime. Corpus delicti plus confession equals guilt. Plea of guilty, not enough, not bailable. Confession, enough, bailable. Evidence means sanctioned by the rules used in judicial proceedings in proving or ascertaining the truth. Means it's a tool. Sanctioned by the rules of court specifically provides for evidence. In judicial proceedings, in judicial courts. However, evidence is not applicable in Nicole. Nicole means naturalization, insolvency, cadastral, other cases, land registration, and election cases. There is a need for evidence only when there is a question of fact. How about question of law? No need if a question of law, no need for evidence, cause the trial is not necessary. When are circumstances of evidence not required? Judicial notice, presumption of law, and judicial admission. Kinds of issues. Question of law, trial is not necessary, hearing only. Question of fact, needs evidence. Trial and hearing. Trial is the presentation of evidence, or the presentation of evidence is required. Hearing, evidence, or arguments are sufficient. If there is no issue of fact, you can ask the court to render judgment. What are the different kinds of evidence? You have the relevant and competent evidence. Hindi pwedeng relevant lang or competent lang. They have to go together. Relevant and competent. Example, no warrant of arrest, pero kinuha yung bolo. Is that relevant? Yes. Is that competent? No. The evidence was secured illegally. Letter of a man to a woman, my dear wife. Is that evidence that they are husband and wife? Relevant? Yes. Competent? No. Direct or circumstantial evidence. Direct, there is a witness. Circumstantial, interlocking events. Corroborative or cumulative evidence. Corroborative, different pieces of evidence, but they basically prove the same thing. Cumulative, same kind of evidence. More witness, better evidence? Nope. Quality is important in evidence, not quantity. Positive and negative evidence. Positive, I did not see the accused. Negative, the accused was not there. Ordinary and expert evidence. Ordinary, layman. Expert, knowledgeable, an authority in a specific field. Sometimes it's okay. Ang ordinary, minsan, di na necessary an expert. Kasi example, lasing. Di naman na need ng expert to say na lasing yung tao. Electronic evidence, any evidence generated using electronic devices. Admissible, ang text message. General types of evidence, real or object evidence, addressed to the senses of the court. When the court has to use its senses, demonstration is a very important thing as it surrounds knowledge in the commission of the crime. Pakita mo paano sinaksak. Documentary evidence, anything written, a figure, symbolic or symbol, etc., like tombstone. When did the accused die? Document, writing on a surface becomes a documentary evidence. Testimonial evidence, statements on a witness stand. Question whether or not judicial affidavit a documentary evidence or a testimonial evidence depends on how it is needed as evidence. Kinds of evidence, stages of proceedings. Evidence in chief, direct testimony. Rebuttal, opposite of evidence in chief. Sur rebuttal, contradicts the rebuttal. Prima facie evidence, sufficient to prove fact in issue. Prima facie evidence, as we have discussed, it is necessary to establish an issue in fact. Prima facie case, no need. Most important rules in evidence. Original document rule. When the subject of the inquiry is the original, there is no other admissible document but the original. A duplicate document may be admissible. It is the copy of the original which was generated at the same time or with the same impression as the original document. Waivable if the copy is not properly objected to. Persons not parties cannot use the original document rule. To be able to invoke such rule, the person must be a party. Parole evidence rule. When the terms of the written agreement or contract are being questioned, no admissible evidence except for the document itself. Evidence aliunde. The rationale of PR is based upon the fact that sanctity of a written agreement. Waivable. Hearsay rule. Based upon the fundamental rule that witnesses may testify only based on their personal knowledge. On perception, hindi sabi-sabi. If the declarant makes a statement outside the court, hearsay. If in court, di na siya hearsay. Exception of PR must be raised in the pleading kapag clear and walang ambiguity, okay lang. When there is a latent or intrinsic ambiguity, present testimonial evidence, PR may be admitted. When the agreement does not reflect the intention of the party, prove the true intention by PR. Or if walang PR, pwedeng action for reformation. Important exceptions to the hearsay rule. Dying declaration, very serious condition, conscious of death, declaration cause of impending death, later on dies. Why is this allowed? Because a person who is about to die will not lie. A person is testifying on behalf of the dead. The declarant must believe na mamamatay na siya, not 3 days after the incident na buhay pa. Yung mamamatay na. The declaration is yung cause ng impending death. Res gestae, startling event, nakakasindak. Stress of excitement, no time to invent stories. Why allowed? Because the declarant is under high stress or surprise, thus he cannot lie. May spontaneous statement from a truthful mouth. Common reputation. If there is no marriage certificate, it can be proven by secondary testimony and common reputation. Si A and B nakatira sa isang bahay, may 10 anak, parehas last name, etc. Res inter alias acta. Kung si Pedro ang nagsabi, si Pedro lang. You cannot make anyone account for someone else's actions or words. Except conspiracy. If the conspirator makes a statement outside the court, bawal yun. Magiging exception lang ang conspiracy if the admission is done in court, judicial admission. Like the example of justice, hampas sa kalabaw, latay sa baka. If you say something, you are responsible for it. Major kinds of evidence, we have the real or object evidence, documentary evidence, and the testimonial evidence. Whether or not a book is an object evidence or a documentary evidence, it depends on the purpose. If it is the contents of the book, documentary evidence. If it's the book as a book, object evidence. Secondary evidence, copy of the original, first. Recitation of the contents, second. Testimony of the witness, third. It's a hierarchy. original document, public documents, form part of official records under the custody of a public office or a public officer cannot be moved out of the office. Certified copy, original, notarized document, significance, no need to authenticate because it's self-authenticating. Private documents submitted in compliance with law. Let's go back to the judicial admissions. In admission, oral or written, made by the party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not in fact made. Note that this is the highest form of evidentiary admission, although unless it is an injustice to the adverse party. Requisites of judicial admission: the same must be made by a party to the case. The admission must be made in the course of the proceedings in the same case. And 3, there is no particular form for an admission. It may be either written or verbal. What are those that do not need to be proven? Admissions made in the course of the proceedings, admissions in amended pleadings, dismissed pleadings, pleadings that are not filed, admissions made by the counsel, implied admissions of actionable documents when there is failure to specifically deny or a negative pregnant. Is it final that the admissions made by the counsel do not need to be proven? No. In cases of reckless or gross negligence of counsel, specifically when it deprives the client of due process or outright deprivation. Is a crime bound by the wrongful admission? Suppose the lawyer made an adverse admission. Is this the counsel's fault? General rule is that the lawyer can bind the client. However, if there is denial of due process or the lawyer is the one culpable, the client is not bound. What is mandatory judicial notice again? Mandatory judicial notice is when the court is required to accept as fact certain matters herein enumerated and without the introduction of evidence. 1. Existence of the territorial extent of states. Example, if there's an issue of fact on the territory of the Philippines, the Supreme Court should take into consideration and assume that the West Philippine Sea is part of our territory. Number 2. The political history of the Philippines. The judge is presumed and mandatorily required to know the history of the Philippines. 3. Forms of government of different states, symbols of nationality, the law of nations, the Admiralty and Maritime Courts of the world and their seals, the political constitution and history of the Philippines, laws of nature, official acts of the executive orders, legislative statutes or judiciary decisions, measure of time like 60 minutes is 1 hour, etc. Geographical divisions, this is needed specifically for boundary disputes resolved by the courts. How about discretionary judicial notice? Discretionary judicial notice happens during the trial. Here, the court may announce that it is taking judicial notice of some facts, and the court will take the comments of both parties. Judicial or discretionary judicial notice is when a court may take judicial notice of matters which are of public knowledge, or are capable of unquestionable demonstration, or ought to be known to judges because of their judicial functions. What are these facts? Facts of common knowledge, usually of notoriety. Example, everyone knows how traffic it is in EDSA. Demonstration, if it can be demoed in court, it becomes unquestionable. Example, scientific findings. Court knows as a consequence of his judicial function. This is basically the judge knowing his or her job description. Sino-sino employees and staff niya. Ilan ang employees and staff niya. Why? Because siyempre, sabi nga ni Justice, baka mag-fire ka ng di mo naman employee, di nakakahiya kasi iaangat pa to sa Supreme Court. Departed judicial notice. In departed judicial notice, there is a need for notice and hearing. Unlike in discretionary and mandatory judicial notice, departed judicial notice can also be initiated motu proprio or by a motion of a party. During the pre-trial and the trial, the court, motu proprio or upon motion, shall hear the parties thereon if such matter is decisive of a material issue in the case. Example, if a witness is, let's say, duling, and claims that he can see the accused clearly, pwede magpa-departed judicial notice to make sure tama or magkaroon ng expert evidence. So what are the things taken cognizance of? Ordinary experience of man.